Hi, I'm Charles Hatley with Malone Hatley PC, where we truly are your partner for the divorce and estate planning process. This is our podcast on how to pronounce your divorce, where each week we talk about topics that are important to you who's going through divorce and help educate you on what you can expect through this process. Today I'm joined by Rebecca Malone, and we're going to talk about attorney's fees. The reality of getting the attorney's fees, the reality of having to pay attorney's fees, when attorney's fees are appropriate, and what is an attorney's fees award in reality. So, Rebecca, my first question for you is, what is an attorney's fees?
Sure. So attorney's fees can be awarded in either direction, and really at any stage of the case when you're going through a divorce in Virginia. So it's important to understand what each kind of section of the case breaks down to and what somebody might be entitled to at each point throughout their case. In general, we don't have a rule in divorces where it's like the winner, the loser has to pay the attorney's fees or something like that. In general, the American rule across the board is that everybody's expected to pay their own attorney going into any type of civil lawsuit or anything like that. And so divorce is no exception. That's where we're starting. We start with the expectation that everybody pays their own attorney. Everybody's responsible for their own attorney's fees when they're going into court. But there can be grounds to have one side contribute or pay all of the other side's fees during the course of a case.
And, attorney's fees is, like you said, the American rule is everybody pays their own way. However, in divorces, sometimes there's such an inequity in the amount of money that people, you might have somebody that's a stay-at-home spouse who has access to one credit card, and you have somebody else that goes to work every day and they make $250, $300, $400, $500,000 a year. So every other week they're getting a paycheck deposited into their account. And it's not uncommon in the divorce process. It's actually advisable to start dividing your bank accounts as soon as possible, right? So if you're the one that is the lower earning spouse, maybe you want to start stocking money away in a bank account that only you have access. If you're the higher earning spouse, you want to start having your access to your money, make sure the other person doesn't drain the bank account. And so it's not uncommon for a discrepancy to exist. So in cases where you have somebody making a lot of money, it is really tempting to go to court and say, hey, it's not fair. They make $500,000 a year. I make zero. I'm at home taking care of a decrepit parent, and they're claiming I committed adultery. How am I going to be able to afford to fight that? I'm part of the court receptive to that argument.
Right. So again, it breaks down by each sort of stage of the case and then what's involved. So at the beginning of a case, what the court is looking for is how much is this going to cost each side to get through the entire thing.
Mm-hmm.
We still have to go through discovery. We're going to have a trial. We may have to do some depositions or something like that to prepare. And so what can each side expect to have to spend in order to pursue their case or in order to properly defend their case? And then the court looks at the overall equities of the situation. And so when you have a situation like that, where you have one spouse who makes all the money, another spouse who makes absolutely nothing, there's a really good chance that they're going to have to make a contribution. The higher earning spouse is going to have to make a contribution toward the other spouse's attorney's fees. And it's for the purposes of kind of funneling or furthering the other side's case as they go forward. Now, as you get into it, there can be different grounds to have attorney's fees awarded later on in the case. But at the very outset, we want to give everyone not necessarily a completely equal playing field, but we want to have some sort of access to justice. We want to have some sort of ability for each side to get to the next stage of the case and be able to adequately represent or defend their interests.
Kevin, that's exactly right. When you have, and that's where we'll talk about the other sides of attorney's fees, or somebody's done something wrong, or frustrated litigation. But when you have such a disparate incomes, you can go to the court and say, look, it's not fair, man. I can't afford to pay this. This person, with each paycheck, will be able to spend more than I can afford to spend on this entire divorce. And they're making some pretty bold claims about me that I need to defend. On the other hand, if you're a higher earning spouse, it feels really bad. Let's imagine you're in a situation, the higher earning spouse, the lower earning spouse commits adultery. And now the court's saying, well, yeah, they might have committed adultery, but go ahead and pay their attorney's fees. So we're going to make you pay their attorney's fees so that they can try to prove that they didn't hurt you. Seems unfair. So that's why it's very important to have an attorney that's going to think outside the box and say, look, I acknowledge that the other side doesn't have any money, right? You're not going to get around that. We're not going to go to court and make some really good argument that the other side secretly does have money, unless they do, right? If they do, you should. But no court's going to be convinced that, oh, well, they should be able to pay their own way because even though they make $0 and they don't have any family, somebody's going to help. It's not going to work. But let's say your house has a lot of equity. Say, Your Honor, I'm willing to front your attorney's fees for return on payment from the equity. Of course, like that. Like you said, the American rule is to say, look, you pay your own way. And you're telling the court this person does have the ability to pay their own way, just not today. And so what I'm going to do, I'm not going to sit here and pretend that they can afford this. I'm just saying, if I have to pay attorney's fees if I have to front attorney's fees just because of the discrepancy in income, that I'll get repaid once we divide the equity in the home. And that's about the best argument you're going to get. If you have a judge that's in a position and a willingness to give attorney's fees to the other side and you're the hiring spouse, start looking in terms of the other assets and say, but in equitable distribution, I can get paid back. Courts love that idea. And then make sure the order is written clear enough that you actually do get paid back. So what about in situations where you're asking for attorney's fees, you're still a lower earning spouse? What's the best way to ask for attorney's fees? Like say, hey, I want $50,000 up front, or hey, you pay me $3,000 a month, or something like that. What do you find to be the best way?
Right. It needs to be based somewhere in reality, right? So the attorney can look at your case and say, look, we're going to have to do discovery. We're going to have to do some depositions. Our trial is probably going to take 2 or 3 days because we have a whole lot of assets. Whatever it might be, but your attorney can kind of crunch some numbers and say it's probably going to take this amount of time to get through whatever it is that we have coming up. And then they can base their attorney's fees request on that. The judge doesn't want you to just come in and say, well, how much will you give me? I want $100,000. Sure, sounds good. What is that based on? You have to have some sort of basis for it. So if the attorney can reasonably say, look, it's going to be a 3-day trial. It's going to take me at least this long to prepare. We've got this many witnesses. We're going to be conducting depositions. These are the expected expenses, or these are the expected fees that we're looking at for this particular case at this time. And it doesn't mean that it's like free money forever. The court can always come back later and say you have to repay it, or there's going to be an offset somewhere else to make up for the fact that you had this, influx into your attorney's fees at the beginning of the case.
And you can also look at the claims being made. The example I gave where the higher earning spouse is claiming that the lower earning spouse committed adultery, especially in cases where the claim isn't very strong, right? Like it's like on information and belief, I think they cheated on me. I mean, that's not a strong claim, but they're still making it, and it still costs money to respond to that. It actually strengthens your argument if you're the lower earning spouse who will get attorney's fees. And if you're the higher earning spouse, you may want to think about the claims that you're making. Like if you don't have a strong adultery claim, don't make it. Right? And you see this all the time because a lot of jurisdictions that we practice will use adultery as a bar to spouses. And so a lot of the higher ranking spouses will just broadly make a claim to adultery. And it's very inadvisable to do that. Because then, like I said, if I'm representing a lower earning spouse, I'm going to say, Your Honor, now I've got to defend against this claim that wasn't even properly drafted. And this starts getting into attorney's fees for frustrating litigation or bad acts. Can you kind of explain to us how those attorney's fees work?
Sure. So after kind of your initial hearing, and as you're sort of walking the case through the next stages, if you have one side who is not responding to discovery, they aren't showing up for depositions, they refuse to schedule court dates when you're trying to schedule court dates, they ask for a continuance every single time you show up to court, right? Things like that are causing the attorney's fees to go up and up and up and up and up because we keep having to do the same things over and over and over again. That's another basis to ask for attorney's fees. And so what that's called is frustrating the course of proceedings, right? So the court's looking at the overall equities of the case. Is one side frustrating the course of these proceedings, refusing to respond, refusing to participate, not showing up, asking for continuance after continuance and excuse after excuse, then there can be a penalty, basically, or a sanction against that side in the form of attorney's fees, that look, the other side didn't need to spend this much on attorney's fees, but for your refusal to cooperate.
And you should, like you said earlier, come to the court with a definite amount, right? Your
Mm-hmm.
attorney should say, look, they did X, Y, and Z. X, Y, and Z put together, and my hourly rate equals this many dollars. Court, I want this many dollars back. Because, judges hate, well, I'll tell you exactly what a judge will do. You say, Your Honor, I want attorney's fees. And they'll say, well, we'll reserve the issue of attorney's fees till trial. If you didn't have, you can say, look, Your Honor, my client had to spend $10,000 extra on attorney's fees because of these bad acts. And we all agree, bad acts, right? Not responding to discovery. We all agree they didn't respond to discovery. We had to spend an extra $10,000. And because of that $10,000, this $10,000 my client now does not have to go to trial.
Right.
And then you get a judge that is much more likely to award you attorney's fees during that process, even if it's the lower earning spouse that's frustrating litigation. When we're talking about attorney's fees award, of course the court's going to look and say, well, this person has $0. I'm giving you attorney's fees from their spouses. Like, what do you want me to do? In that particular case, you're very unlikely to get a cash award, but you could say, I want $10,000 for return of my attorney's fees out of their share of the equity of the home. And the court, okay, that actually sounds pretty legit. The court will be much more open when you come with a definite idea and a definite, I always tell people, come with an ask, right? Ask for what you want. Don't just say, well, Your Honor, we want some attorney's fees and we don't know when the other side's going to get them, and I don't know how much. Of course, I'm going to say, I will reserve that issue.
Right.
And you've really screwed up when you don't ask for a certain amount and the court reserves the issue for later because the judge will probably give you the amount from somewhere. So, what if you are the higher earning spouse and your plan is, I'm going to break the other side? Does that work?
No. And for those exact reasons, right? So you're already most likely, having to pay an initial amount towards the other side's fees, which they're going to use to then do discovery. And then if you're not responding to the discovery, you're trying to delay things, you're trying to drag it out, or you're on the flip side, you're trying to do like a document dump, right? Where you just give them every single piece of paper that has ever come into your life. That's going to be viewed negatively by the court as well. And so if you say, look, we asked, 30 questions and it should have been like 20 pieces of paper, whatever it was, right? And they gave us boxes and boxes and boxes of materials that are completely unrelated. That's bad faith, right? The court's going to see right through that. And so again, you're going to be penalized or sanctioned for making the other side now have to do this additional work and comb through all of these extraneous materials that you've sent over, and things of that nature. So really, it doesn't necessarily work to try and just drum up the fees as much as you can, or try to like generate more work where there isn't anything to really legitimately do. And if you're going in on hearing after hearing after hearing without a solid basis for it, again, the court is going to say, we're not going to keep putting you on the docket at a certain point. You have to actually have a basis for your motion. It has to be filed in good faith. And so that's really a poor strategy. And most likely, if that's what you're going in with, you're going to have an attorney who's going to end up withdrawing, because they're not going to want to have their name associated with practicing that way in front of judges that they're going to be in front of all the time.
Well, they should want to withdraw. We know that there's people who will stick on a case. Some attorneys will stick with whatever case is willing to continue to pay the bill. And that's unfortunate because there are people with really bad plans, right? And you'll get an attorney that says, look, okay, fine, if that's what you want to do. The attorney knows what's going to happen. They know you're going to end up having to pay the other side attorney's fees, but as long as you're paying their bill, they don't care. So it's very important to have an attorney that's going to look at you in the eye and say, look, this is a bad plan. And I'm going to tell you why it's that way. Because of X, Y, and Z reason. And, I've had to look people in the eye and say, look, I know that the other side is asking for attorney's fees. And good point, you get it. There's such a discrepancy in the income. Like, really, I had a client who made over $1 million a year, and the other spouse made zero. And had access to none. Another spouse made zero and had access to literally no bank accounts, no dollars, no credit cards. is, again, they're going to get attorney's fees, but let's structure something different. Let's structure it as an advance out of the equity in the home. And the other side agreed to it. So without ever even needing to go to court, the other side agreed. And so my client did pay the attorney's fees and was relatively salty about it, as I would expect somebody. But we were able to think legitimately about it. And it doesn't mean that that particular client wasn't still able to succeed because of financial resources, because that client didn't succeed. And the other client ended up taking a deal that was probably not the best deal in the world. So there is a way to walk that fine line, which you're looking for an attorney that can be honest and say, look, this isn't, especially when you start frustrating the litigation process, right? If you're not responding to discovery, like, oh, I want to make them file a motion. I want to make them do this. But there's a flip side of this. What about the other side that refuses to do anything, right? They refuse to respond to your email. So as an attorney, you send the email to their attorney, they refuse to respond. They refuse to do this, they refuse to do that, they refuse to set hearings. You try to have every hearing you try to have go town. What do you do in those instances as far as attorney's fees are concerned?
You just take it to court and you put together your argument for attorney's fees. This is the number of times that I've contacted them, and you lay it out there as crystal clear as it can possibly be that there's no other solution other than some sort of sanction against this attorney. That, I emailed them on this date. I provided them with 3 different dates. They've refused to respond. Up until today, they've still refused to respond. I've called their office. Here's the records. Here's the emails. Here's everything all attached. And so you basically leave the judge with no other choice. They have to do something about this. We can't have attorneys that are practicing in our courtrooms and behaving this way. This isn't a legitimate way to practice. And so I recommend putting together a motion and a brief and making it as crystal clear as it possibly can be. And then again, being really specific with exactly what you're asking for. Look, I spent this much time sending follow-up emails and emails and emails and emails and phone calls and phone calls and phone calls and phone calls, right? And this is what it's all added up to, that my client has now had to pay because the other side refuses to answer the phone, right? That's just ridiculous. And so you have to walk the court all the way through it. And then hopefully there's going to be some sort of resolution. And for something like a refusal to set a court date, in a lot of courts, you can put a motion on the docket to set a court date. And so the court, once you have a judge actually sitting there and saying, this is the available day, eventually they're going to run out of excuses and something's going to be scheduled.
It is. And, you brought up the not returning phone calls. That's why you always send an email. Always send an email. Every single time I call an attorney, there's an email that follows and says, hey, I just tried to call you. Is there a time we can schedule to get a phone call again? And then, I set myself a reminder because they forget it. And at the end of the year, you're fine. We'll start to forget, like, oh, yeah, they didn't respond. Oh, yeah, we sent this. They didn't respond. But that's why it's very important, man. I always suggest taking the time to sit down with your attorney to have a strategy session on what the other side strategies are.
Yep.
And I'll give a perfect example. You have a client sitting in a completely paid off house and they're not paying any bills. They don't want to negotiate with you at all. They're living for free. The sooner that divorce goes through, the sooner the reality of them having to pay bills hits. And so sitting down and having that strategy session, thinking about what is the other side's incentive for how they're going to act, can help you act quicker. And so when you're thinking about in terms of attorney's fees, being able to sit down and say, craft your argument. Your Honor, we're sitting in a house that's completely paid for. They have every incentive in the world not to act. We need to incentivize action. Because to date, I've tried in good faith, I've sent emails, I've called on these days, I've contacted them on these days, I contacted the court, I got bid dates, they refuse to respond, hasn't worked. And so, when you're wanting attorney's fees, I think it can be best summed up, know what you're asking for, know the amount that you want, and document everything that you're doing. So, Rebecca, I want to thank you for talking about attorney's fees today. It's always a frustrating point of view. If you're the higher earning spouse, it's frustrating to have to pay them. If you're the lower earning spouse, it's frustrating to not have the money to pay. If you enjoyed this conversation, please subscribe for weekly tips and advice on how to best succeed in your divorce case. And if you or someone you know is going through a divorce, give them on how APC a call and see the difference that a partner can make in your case.